Hello everyone, I am Shivani and welcome to Vakilaw, Know the Law. In today's session, we are discussing about the subject of drafting, pleading and conveyancing. In my previous session, I have discussed about drafting. I have shared a link of the video in the description box below. Do check that out. So today we are discussing about an important topic which is pleading. So as professional lawyers, pleading, rather effective pleading, is the soul of a successful advocacy. So it is important to understand that a good pleading leads to effective representation of our client before the court of law. So in my previous session on the subject of drafting, pleading and conveyancing, when I was discussing about the drafting part, I stated that an effective and precise draft helps the client in gaining favorable judgment. But it is also important that along with an effective draft, it is important that we have an effective and efficient pleading before the court of law. So it's not only about the drafts or the paperwork or the document work that we make, but along with that, it is important that we plead before the court of law on behalf of our client, as we are representing our clients before the court of law in a very effective and efficient manner. So we lawyers, as representatives of our client before the court of law, are required to plead our client in the best effective manner. So in this case, pleading plays the most important role for a successful advocacy. The judicial structure of India, along with the Constitution of India, has three major laws or acts. So these are the procedural laws, which provide for procedures as well as provisions regarding the same for how disposal of matters are made before the court of law. So which are these three major laws? So the first one is the Code of Civil Procedure of 1908. The second one is the Code of Criminal Procedure of 1973 and the Indian Evidence Act of 1872. So the Evidence Act is an act which corroborates the civil and criminal procedure codes. So again, now coming back to the topic of pleadings, let us now discuss about the meaning of pleadings or the concept of pleadings. Order 6, Rule 1 of the first schedule of the Civil Procedure Code of 1908 deals with pleadings. So pleadings in simple terms means plain and written statement. If the pleadings are not properly framed, the party in question would be in a disadvantageous position. So it's important to note that pleadings should be properly framed, they should be in a proper format, because if it is not made as per the requirements of that particular act or as per the requirements of the procedural codes, the party who is in question will certainly fall into a disadvantageous situation. So it is also very important to note that the case of a party must be set out in his pleadings. So this is the most important part of pleadings, that the case of the party is the one which is to be set out in his pleadings. Next, relief cannot be claimed on the grounds which are not contained in his pleadings. So anything which has not been added, not been contained in the pleadings, is the thing which cannot be sought as a relief to the party who is pleading. The next thing is, it is essential to ensure that the specific pleadings or setting out the material facts must be given in the pleading in order to claim the relief on that basis. Next is, no relief can be granted in respect of which a specific mention has not been made in the relief portion. So anything which has not been included in the document or neither in the pleading is the thing that cannot be asked in the relief which has not been mentioned in the relief portion it cannot be sought before the court of law. Now it is also essential to understand that no party can go beyond its pleadings. So you have to stick to the frame of the pleadings and accordingly act. You can't go beyond your pleadings. Now moving towards the main part. So what is the main objective of pleading? So the sole and main object of pleading is to give a fair chance to the parties to know the case of each other. So this is what is the main motto or main objective of pleadings. Now the next question is, what is the purpose of pleading? So the purpose of pleading is to eliminate vagueness and ambiguity. So the frame that has been created in the pleadings will certainly give a clear picture to both the parties as well as to the court of law, and will help in efficient disposal of the matters, and also the parties will know about what they have to say before the court of law or what is their side of the story. So that is what is the main purpose of pleadings. Now moving towards the next part, we will be dealing with the fundamental or general rules of pleading. So the first one is, pleading should contain material facts only and not the law of evidence. In short, the pleadings should not contain any evidences. Next is, all relevant facts should be stated which are relied by the party, and evidence by which they are proposed to be proved should not be disclosed. So it is only the factual part which is to be mentioned in the pleadings, and no any evidence is to be provided at that time. Next one is, the facts should be stated in brief without ambiguity and vagueness. So they should be particular, pinpoint, they should be in a brief format, and at the same time it should not contain any vague or ambiguous statements. Next is, the entire law of pleading is laid down in the provisions of Order 6, Order 7 and Order 8 of the Code of Civil Procedure of 1908. So Order 6 of the Code of Civil Procedure of 1908 deals with the general principles to be adhered while drafting and further dealing with pleadings. Order 6, Rule 14 of the Code of Civil Procedure of 1908 provides as to who should sign the pleadings. Next, Order 7 of the Code of Civil Procedure of 1908 deals with the rules to be followed while drafting a plaint. Next is Order 8 of the Code of Civil Procedure of 1908 deals with the drafting rules to be followed while framing a written statement of the defendant. Next is that along with these rules, some procedures in regard to the practice are to be followed or observed before filing a case in the court. So the rules that I have mentioned are to be strictly adhered to by the parties to the suit. So the parties who are in charge or are related to the suit are the ones who should strictly adhere to the rules that have been stated right now. And the last is, non-observance of these rules may lead to disastrous consequences. So if these rules are not followed or are not complied with, it will certainly cause a problem to the party who goes against such rules. Okay, so now we've seen the general or fundamental rules of pleadings. Now let us move forward towards the object of pleadings. So what are the object of pleadings? So first is knowing exact issue. So the main object of procedure of pleading is to ensure that both the parties at dispute should know the exact points of such disputes between them, so as to bring forward their own case and evidence to determine the issue. So to know what is the exact issue or what has happened or what is one asking for before the court of law in that particular matter, to gain such knowledge is the main motto or main objective of pleadings. Now the second object is knowledge of allegations and defense. So the defendant is entitled to know what is that the plaintiff is alleging against him. The plaintiff in his turn is entitled to know what defense will be raised in answer to his claim. If the parties themselves are not aware of what they are fighting about and what the opponent exactly wants, it will create a lot of confusion and ambiguity. So the next objective is prevention of miscarriage of justice. It is thus amply clear that if pleading is not clear or are ambiguous and the parties do not get the opportunity of meeting their opponent's case respectively, there would obviously be a miscarriage of justice. Now what are the other objects? So along with the objects that I have stated, the other objects of pleadings are to bring parties to the real issue, to avoid unnecessary delay, and to reduce expense in procuring evidence required by either party at the hearing of the case. Okay, so now we are enough clear about the object of pleadings. Now let's move forward towards the functions of pleadings. So the first function of pleading is that the function of a pleading is not only for the sake of party but is intended to provide assistance to the court by stating with precision the area beyond which the dispute must not be permitted to extend. So in simple words, its function is to help the courts to determine the limits of the case, the point or points of issue and the prayer that the parties have made. This helps the court to handle the case meticulously and with precision. So the Honorable Supreme Court of India, while commenting on the object and purpose of pleadings, has observed that the object and purpose of pleading is to enable the adversary party to know the case it has to meet. In order to have a fair trial, it is imperative that the party should state the essential material facts so that the other party may not be taken by surprise. The pleadings should, however, receive a liberal construction. No pedantic approach should be adopted to defeat justice on hair-splitting technicalities. So the main function of pleading is given in a general rule that the relief should be founded on pleadings made by the parties. So the main function of pleading is to provide relief to the parties. Okay, so in our today's session, we discussed that as advocates, pleading plays a vital role for successful advocacy. So I have also discussed that judicial structure of India contains, along with the Indian Constitution, contains three major laws, which are procedural laws, which are the Code of Civil Procedure, the Code of Criminal Procedure and the Evidence Act, so which is an act corroborating the procedural laws. So moving towards the pleading part, I discussed about the meaning and the concept of pleadings. Later we discussed about the fundamental and general rules of pleading. The next part was the object of pleadings. Then I discussed about the functions of pleadings. Now in my upcoming session, I will be discussing about the fundamental rules, which are the substantive rules of pleadings. So don't miss my next session. I hope you like my videos. If you like them, please hit the like button, share my videos, and yes, don't forget to subscribe to my channel Vakilaw, Know the Law. Till then, this is me Shivani signing off. Bye bye.